Hi, folks. It's 1 o'clock, even though that clock is a little ahead, but we're taking time off of my iPhone, and so we're going to get started. Thank you for coming today. My name is Yoselin Galeano. Everybody calls me Yossi. I am the village manager of Pinecrest, and I am joined by Mr. Chad Friedman, our deputy village attorney. I'm just going to give you a quick overview of what to expect today. My presentation is actually about 10 minutes long. It's not long, very long at all. What we are doing differently than other past town hall meetings is right now we're actually recording, because everything that we're going to be talking about today is going to be used and put online to educate folks that can't make it out to the town hall meeting. So we're being recorded. We've handed out some index cards for folks to write your questions. What we're going to do is go through the whole presentation, about 10 minutes, and then we'll open it up for questions. Staff will walk around, pick up the questions, and then we'll just take as long as it needs to get through all the questions. Last time we were here for about 2 hours, so depending on how much, I'm going to try to cover some of those same topics during this presentation to hopefully answer your questions while we're doing the presentation, but of course, we'll stay here as long as we need to get through everything. So thank you for that. I want to first talk about the role that the village has in this particular meeting. We are here to help educate you on the topic of the referendum, that the special election that's going to be happening. Our position is neutral. We're not here to debate anything. We're going to be presenting information strictly from a legal perspective, with an explanation of how we run today versus what would happen if this were to go into effect. So everything we say today obviously is meant to clarify questions for you. There are no silly questions. Feel free to ask away. I know there's a lot of information being put out there, so anything lingering that you need questions on, even if it's not related to this, we'll hold those for the end, but we will get through those as well. So one of the things that I do want to emphasize to everyone here is what's in our charter. And there are copies of, not the entire charter, but we added excerpts of the charter because we're going to be going through some of those articles that are relevant to what's happening in the special election. But the one that I really want to focus on right now is what we call the Truth in Government article that's in our charter. And I'll just read it out for everyone. It says, no municipal official or employee shall knowingly furnish false information on any public matter, nor knowingly omit significant facts when giving requested information to members of the public. There's a subsequent section of our charter that talks about remedies for the violations of this section of the charter. And it talks about how any public official or employee, like myself, who is found by the court to have willfully violated this article shall forthwith forfeit his or her office or employment. So what that means is everything we're saying to you today is framed from the position that I, as your manager, and Mr. Friedman, as the village's attorney, represent you as residents. Everything we say and how we present information can be used against the village, you, the taxpayers, in a court of law. So the information that is provided here is factual, accurate. There are no opinions interjected. That's not our role here. It's a neutral role. So we're not here to tell you how to vote. We're just here to give you the information on how this might impact us, and then you all make your own decisions on the vote. Okay. So presently, there's 3 ways that you can amend our village charter. The one that we've always used, if you look at the handout that we gave on the charter, you'll see the first page, the title page, talks about how things have been amended over the years. Those amendments have always occurred through what's called the Charter Review Commission. It's a board that is appointed by council every 6 years, and they review the charter and make recommendations for changes to the charter. Those recommendations are brought to the residents in a special election, and sometimes things get passed, sometimes they don't. So you'll see here there have been amendments to our charter in the past, but all those amendments have been started through the Charter Review Commission. You have 2 other ways that you can amend our charter. One is through a council-initiated way. We've never done that in that format. And then the third way is by petition, which is what is coming before you for a vote through the special election. So the process that we're going through right now was initiated by a petition. So we have an upcoming election, special election. So when we say the election is by March 7th, that means that the ballots must be in and turned in the possession of the Dade County Elections Department by March 7th, not postmarked by March 7th. So if you find yourself still holding on to a ballot that day, you need to drive it to the Elections Department in order for it to count. Every registered voter in the village will receive a ballot by mail. So every single person that's registered to vote will get it. They don't have to request it. It'll automatically be sent to everyone. You should already have it. If you haven't received it and you wait maybe 3 or 4 more days, you need to call the elections department at the county to explain that you have not received a ballot yet. The ballots, again, must be at the Miami-Dade County Elections Department by March 7th. And then there's like a voter certification that's on the back of the envelope. If it's missing a signature, they won't count it. They'll throw the ballot out. You also need to make sure that you have a return address on the envelope. So those things are all critical in order for the elections department to not throw out the ballot when they receive it. Okay, so you're gonna ask, what is actually being voted on? So you'll see here, this is the language, and I'll go more into detail what it means, but for right now, I'm just gonna read it out. There's 2 parts to what is gonna be before you. What you see all in caps is the title. That is not what you're voting on. What you vote on is the language below that, which is the actual ballot measure. So I'll read you both. The title is Charter Amendment requiring 60% voter approval for certain zoning code land development regulation amendments. What you're voting on is the charter would require 60% voter approval for text amendments to the zoning code or land development regulations that would create a new zoning district, amend any definition in the land development regulations, or have the effect of allowing uses not currently permitted, increase residential density, allow additional hotel or accommodation units per acre, increase lot coverage, increase height, or increase floor area ratio. And you would vote yes or no. So what does that mean? First of all, I want to stress that this language, if it were to pass, affects the entirety of the village, not just US 1. And we'll go over each of the things. So the ballot is asking Pinecrest voters to decide if they would like to amend the village charter, which is our constitution, by adding a new step to the current process that would require a referendum approved by 60% of voters every time there is a text amendment to the zoning code or land development regulation that A, creates a new zoning district, and or B, amends any definition, and or C, has the effect of allowing uses not currently permitted, and or D, increases residential density, and or E, allows additional hotel or accommodation units per acre, and or F, increases lot coverage, and or G, increases height, and or H, increases floor area ratio. So that means anytime anything that changes any one of those things or a combination thereof, it would trigger a referendum. And that is not how we operate currently. So I'm going to show you, to give you an idea of how this would have impacted us had this already existed in our charter. So if this had already been the process we use over the course of 27 years, and March will be 27 years since incorporation, we have changed the land development regulations in such a way that it would have triggered a special election 35 times. And I'll go over more of what that means. What this means is 35 times in our past, we have done what would have triggered this type of special election in the future, if this were to pass or if this were to go forward. So you'll notice what I did here in this table was basically take each one of those bullet points and make a column. So you'll notice some things happen more often than not in our history. Like you'll see here, the second, this right here, it amends the definition. So you'll see all these ordinances here, the 35 ordinances that we've adopted over 27 years have amended definitions that many times. We've also allowed uses not currently permitted all these times. What we've never done is done anything having to do with hotel accommodations, so that's never triggered anything. Like here you see creating a new zoning district. In our history, it's only happened 3 times. So that gives you an idea. So we'll go through how the ordinances happen and how they would trigger an election. So when you have an ordinance that triggers with one of those bullet points, any one of those things can trigger a special election. You would have a special election with a number of ballot measures that you would be voting on. So what does that mean and why is that? Okay, so Florida law restricts ballot language. So what you can vote on, they have very strict parameters that you can only have, for example, the title of a ballot measure can only have 15 words. The actual ballot measure, what you're voting on, cannot have more than 75 words. This is Florida law. So when you take these ordinances and then try to put them into a format where people can vote on it or not vote on it, you're restricted to those numbers. There's always somebody that does that. You're restricted to a certain number of words that you can use. The other thing the law requires is it's restricted to a single subject. So you can't have a ballot measure that has a lot of different things in it. It's restricted to one subject. So when going back to the original, to that last pick, to this, when we looked at these ordinances that we already adopted, we looked at them, how many ballots would that have required? This amount would have required about 54 measures, different measures. So not different elections, you can have one election with multiple measures on them, okay? So that's how we know that these 35 ordinances, in order to have voted on them, had this existed in our charter, it would have taken about 54 separate measures to accommodate or accomplish what these did. Okay, so I want to go over what the current process is. So you'll get a good understanding of how we function today and then how this might change things in the future. So currently, the elected officials, we operate with what's known as a council manager form of government. Council manager form of government is basically a 5-member elected body that acts like a board of directors, and then I'm the city manager, I act like a CEO. So I run the day-to-day operations of the village, but it's based on the policies and the direction of the elected council. Any changes to land development regulations currently require analysis and review by professional staff and technical experts. So anytime we're going to change the law, we'll look at, we get experts that come in, they tell us this is, what you should do, why you should do it, and you're hearing the elected officials in their capacity are hearing testimony from technical and professional staff on a particular issue that helps them make their decisions. The changes to land development regulations are all evaluated against very specific goals. Number 1, to protect the health, safety, and welfare of residents. And they're also looked at from the angle of how they might protect the village's character and also how they might enhance quality of life for residents. Throughout the process, you have citizen input. So anytime that there's a law change, it's done through an ordinance, which requires 2 public hearings. So when you have an ordinance, you say you have the code, they come up with suggested changes to the language, that is heard, it's publicized, advertised, and then it's heard at a public hearing where residents can come up and speak on an issue. Aside from that, obviously, for those of you that have lived here for a while, our elected officials, they all are very available to take phone calls, emails. They'll come to your house So you don't have to necessarily wait for a public hearing to give your input on any matter. You have that ability 24/7 practically with our elected officials. They always make themselves available to residents. The other things that I wanted to go over on the current process is the following. Whenever all interactions with lobbyists or developers have to be disclosed before any quasi-judicial hearing. So there are no discussions with elected, or rather with developers or anyone for that matter at quasi-judicial hearings. The council has to disclose who they've had ex parte communications with. That's the law. Council members also must recuse themselves from voting if there's any conflict of interest. If they have a financial gain in any way, shape, or form from a relationship with whoever may be coming before them. And this is not just on these matters, on any matter. So this applies to anything that happens in the village. The elected officials are by law required to recuse themselves if there is a conflict of interest. Elected officials and staff are subject to financial disclosure requirements and strict ethics standards. What that means is everybody knows what we make and who we make it from. We have to file this every single year. I even provide, when my retirement, IRA bank is, and what house I have, where I live. They have all that information, and it's all required by law to be disclosed. So all the elected officials are also subject to that disclosure requirement. And all the information, again, just to reiterate what I started with in the beginning, all the information that the village officials give to the public are subject to the truth in government provisions that are in our charter. So when you look and have the time, you can go, we did make a list of all those ordinances that I previously listed, and you can actually click on each one of them and take a look at what each of those ordinances did if you have some time. You'll see, aside from that, we put little bullets so you kind of get a sense of what the changes have been and why it was done. But in essence, when you look at all 35 ordinances, they fall into roughly these 4 categories. One is what we call neighborhood protection measures. The other one is environmental protection measures. We have measures that are meant to increase property values, and then measures that were done because of changes in the law that triggered the need to change code. So I'll go over some examples quickly. And again, if you have questions, you can write them out later and we'll go over them in more detail. So for example, neighborhood protection. When you go through those ordinances, you'll catch there's been changes to, for example, we had changed the definition of family in order to be able to regulate fraternity houses, sober homes, and things where you would have like rooming houses, where you would have multiple people that are not related to each other. So that's how we regulate it. We changed the definition. So now, if you're not related in a certain way, you can't live together in a home. That's how we deal with the college rooming houses where you have a bunch of kids all living together. They're not related to each other. We regulate that. We regulate everywhere you see NFIP, and I apologize for the acronym, but that means the National Flood Insurance Program. So we've made changes to our law specifically tied to the National Flood Insurance Program, and I'll go a little bit more into detail of what that means and why we've done those changes. But those changes affect everything from neighborhood protection, environmental protections, also your property values, because it has a direct impact on how insurance companies or the insurance industry establishes rates for flood insurance in the community. So some of those things are regulated through ordinance, through zoning zoning changes. And then finally, environmental protection, for example, we just did illicit discharge ordinance. That has an impact on what is allowed to be discharged in our drainage system that has a direct impact on the health of the bay. So we do things that are environmentally, deal with environmental sensitivities to try to address those issues. Increases in property taxes, we've made changes to the code that affect, for example, corner lots and the way that the houses can be set on the corner lots, what those setbacks are. We've made changes to require that all new homes have the ability to have electric vehicle charging built into their infrastructure when they create a new home. We've made changes that allow green space definition to include people that may have ponds or little lakes in their property to be counted as an open space. And then, like I mentioned, changes in the law. The Supreme Court changed the law on signage, and we had to revamp our entire signage code because of an action that was taken in the Supreme Court. So sometimes different things trigger different reasons for changing the code, but in essence, everything that we've done in the 35 ordinances we've done over our history fall into these 4 categories. So the question's been asked, what if I'm really unhappy with some council decision? Like, what's my recourse? Again, if you have a question, just make a note of it and we'll come back around. But what can I do if I'm not happy with something council's done? The current charter, which you have copies of here, the excerpts are here. By the way, the full cover, the full charter you can find on our website. There's a section in the charter, it's section 5.2 that currently exists that allows for referendum initiatives. So how does that work? Any resident can decide they want to pitch an idea to council and come up with an initiative to change, a new ordinance, and they can do that by petition, or they can also use the same section of the code to try to reverse council decision. So if something happens that people don't like, you could follow the same process that was essentially followed in this with a petition initiated referendum. You would come to council, ask them to reconsider whatever they had just adopted, and if they refuse to change it, it would go to a vote of the people. And it could be reversed. So in other words, the petition would be asking for that to be reversed. So that could be reversed with a simple majority, 50+1 election of whoever comes in and votes for that election. So, okay. The difference between that and what this is presenting is, in essence, the requirement for a 60% approval. So if this were to pass, what would happen is anytime that there is a change or that council changes the land use regulations in one of the ways that triggers a referendum, we would have a special election to basically ratify what council did. And in order to do so, for it to go into effect, it would need to pass by 60% or more. So if the minority of folks at 40% plus 1 vote says no, it does not pass. So it's a little different than how we normally are used to operating. Typically, you go to an election, it's simple majority, 50+1, the majority, whoever the ayes have it. That's not how this functions. In this new system, because of the 60% requirement, even if you have 59% of the folks saying yes and agreeing with council or the elected officials, it would not pass. It would not be ratified, okay? So the other thing that I think is important to mention is the timing aspect of having elections and how they might inadvertently affect the village's ability to deal with things that might be time sensitive. So in our state government, sometimes the legislature in their wisdom will say, we're gonna make a change to the laws, and you're given a window of time that if you have not taken action by which that deadline is, it's called preemption, they preempt, and we gotta do whatever the state says. And the window of time closes, and there's no getting around that. So those things have happened. One example, we had the medical marijuana dispensary, but our attorney had said a better one is what happened with the Airbnb. So back when the Airbnbs started coming into effect, there was the state legislature was lobbied on behalf of the folks that represent the vacation rental industry, and they basically created what's called a preemption. They said, You have until such date to regulate, and if you haven't done so by then, you're exempt and you can't meet that deadline. You know, at that point, you fall under whatever rules and regulations the state dictates. So whenever they do these cutoff preemption type deadlines, the difficulty is that we don't have our own elections department. We depend on the county's election department to run all our elections. So depending on their calendar, even if we were to submit everything to them, they may not be able to schedule an election in time to beat that deadline, whatever that deadline may be. So there's always that possibility. And, you know, it all depends what the legislature does. Sometimes they give you short windows, sometimes it's longer windows of time, but, you know, we have no way of knowing what the future will bring. So that's just something that affects our ability to be agile in terms of responding to things that happen at the state level. The other thing that would change for the village is now we would take on the added process of always having to educate and get out the vote. Because what will happen is you'll likely have these elections at least once a year. Traditionally, if you look at those 35 ordinances, there's been years where we haven't had any, but then you might have a year where you have 3 or 4 changes to the code. So depending on what happens, on average, figure you're gonna have 1 election a year. And every time we have an election, the onus is on the village to make sure that the electorate, that the voters are well versed on what it is they're voting on. We, again, are restricted by law from advocating. The village cannot advocate one way or the other. We can't tell you how to vote. All we can do is give you the facts. But that takes effort. It takes effort to have these town hall meetings. It takes effort for people to come out. And we also really try to get the vote out because we want engagement. And so those are the 2 things that are definitely would be new, are having to do this on a every single year kind of basis. So when we often get questions about, well, what is this gonna cost us? So the costs that I'm gonna share with you now are conservative. So for example, Miami-Dade County, the cheapest way of doing an election in Miami-Dade County is by mail. But we may not always do a mail-in type election, because if it coincides with a general election, we would likely do it all with the general election. And there's different costs associated to that. So off the bat, the election, like a mail-in election like the one we're having right now, is $28,000 to pay to the county. That doesn't include the cost of postage, doesn't include the cost of printing. Also, there's costs, like I said, the educational costs are involved. We would have legal costs that are involved because our attorneys would have to draft the ballot language for all those changes within the parameters of the 75 words and the 15-word limit for the title, etc. And then, you know, any get out the vote. So on average, we've identified that it's going to cost about $67,000 on average every time we have an election. To give you an idea, this election has already cost the taxpayers $115,000 and it's counting. And that's exclusive of any staff time. We're not including our own staff time in there. What we don't know is how onerous this will become, and we'll get a better sense. I was asked at the last meeting, is this going to affect tax dollars? Is this going to result in a tax increase? The answer to that question is, I don't know. Because, you know, on an annual basis, our property values do increase, and we may be able to absorb these costs without necessarily having to raise taxes, but I won't know until we get there. So it may be different on a given year. We don't know. I can't answer. There's no simple answer to that question. So in essence, that is my presentation. Hopefully you got what you need to know.